I see a lot of familiar faces, a lot of new faces as well, names. I'm Andrew Luftig, a partner here at Chase Crowitz Luftig. As many of you know, for many, many years, we were predominantly a real estate law firm. And, we kind of view ourselves as a life event firm. People that are buying and selling real estate often come to us, right, as a result of life events, whether they, just got married or had a baby or got divorced or there's a death, or they, got a substantial bonus. So we do, volume purchase sale. We represent most of the major lenders on financing. We do a lot of commercial work as well, purchase and sale and financing on the commercial end. So it was a natural addition for us to, bring on Chris, who helps run our state department with our colleague Talita. So many of our clients, once they transact in the real estate world, really need some estate planning, and it could be the basic estate planning up until more sophisticated estate planning. To be transparent, I reach out to our clients, when they're initially retained, and then once they close, to say, hey, these are our services. Are you interested in speaking to our estate planning team to learn a little bit more about estate planning? There's no fee. We're happy to have an initial consultation with you. And listen, the old adage is nobody wants to think about these things, right? People kind of push it off. People procrastinate. And obviously, someone will come to us, funny enough, when they're ready to go on vacation, right? Oh no, I need a will. I have 2 kids. It's one of these things where I think there's a lot of misconceptions. First, pricing, right? People think the pricing of these tools, wills and trusts is a lot more intense than really it is. The process we try to make pretty simple, pretty user-friendly. And typically the delays are with the clients. Again, half the time they'll retain us, fill out an intake form and then, not get back to us with some basic information. So there's so many tools and so many things to think about. And this time of year tends to be, reason we want to do this now tends to be, a period where people are more active and thinking about, organizing their personal affairs and have a little bit more energy. So we're going to go over, I think we're going to separate into 2 segments. The first 20 minutes or so, we're going to talk about basics of wills, medical proxies, power of attorneys. The second 20 minutes, we'll talk about trust, because trusts are such a important and valuable vehicle that a lot of clients really don't even know about until they come and speak with Chris. Please, send us your questions through the chat. We'd love to make this interactive. We will send everybody, this PowerPoint. We're not going to make this, presentation heavy, more of a conversation, keep it a little bit more loose, but we will send everybody a presentation, with a lot of definitions, good information. So, Chris, I'll leave it to you.
All right. Thank you, Andrew. And thank you, everyone, for being here today. It's a pleasure to be able to present before all of you. I hope you all find this not only interesting, but helpful and useful. As Andrew had mentioned, the objective is really for us to give a basic explanation here of the basic estate planning tools, but also discuss trusts. We feel like there's a lot of misconceptions out there with trusts, what it can and can't do, that it's honestly that it's something that only very, very extremely wealthy people utilize. And we just want to kind of cut those down, those misconceptions, and show how useful trust can be. Obviously, I'll probably have a little focus here on real estate because we deal with real estate all the time, and that's pretty much one of the biggest assets that anyone can own during their lifetime. Most people have, and show how trust can be useful with real estate, especially with New York City real estate, right? So Here we go. Andrew, I just want to make sure, are the slides changing? Can you see the slides okay?
Yep.
Okay, great. So the second slide here, just our information. We like to make ourselves available. It's our phone numbers, our emails. I will say that this time of the year, it's tax season as well, and I have to answer client questions on tax returns, things like that, so it can get a little intense. But we are here. We do try to get back to you as soon as possible. So yeah, this is for Andrew, for myself, and also for my colleague Talita, who can't be with us here today, but she also assists me with the Trust and Estates Department as well. Now, obviously, I always start with this quote, Benjamin Franklin, who doesn't like to listen to a quote by Benjamin Franklin? By failing to prepare, you are preparing to fail, right? So estate planning, as Andrew mentioned, no one really wants to think about it. Because you're having to deal with questions about incapacity, you're having to deal with questions about death, and even from a personal viewpoint, I'll be honest with you, I'm a trust and estates attorney, and sometimes I don't even like thinking about my own estate planning, but it is necessary, especially when you have people relying on you, you have kids, there are special circumstances. So it's always good to put things into place. Because obviously after you or your spouse or pass away, obviously you can't do that anymore, and the situation can really get compounded afterwards, right? So it's always good to put a plan in place. Like I even have a hard time. I have a hard time getting my parents to put an estate plan into place. So yeah, it's something that everyone should really think about. Now, like Andrew mentioned, I'm just going to go through over some will basics. I'm not going to adhere to this presentation too much. I don't want to bore you guys so much. There's a lot of things in there with terms and things like that. So I'm just going to go through the basics. One thing I do like to mention, though, when at the beginning of discussing what a will is and what a will isn't. Wills are, like, every lay person pretty much knows what a will is. I mean, it's a document that essentially you put in there what you want, what happens at your death, who you want things to go to, and who should be in charge of it, an executor, for instance, and things like that. If there's any specific bequests, those kind of things, right? So what happens if you don't have a will, right? Well, if you don't have a will, you actually do have a will. Right. It's called the intestacy rules, and every state has it. If you pass away, then who gets what is determined by the intestacy rules of the state of domicile. And of course, New York State has its intestacy rules. So I always like with this quotes that everyone has an estate plan. You either create it yourself or one is created by you by the state. And that is the intestacy laws. Intestacy laws are basically someone dying without a will. Who should the property go to? And it's essentially the government's best guess at what they think you would have wanted, depending on who your natural heirs at law are, surviving spouse, surviving children, surviving parents, surviving brothers and sisters, and so forth. Sometimes it matches up to what you want, but a lot of the times not necessarily, right? And then sometimes if you want to leave to charity, you want to leave to friends, you want to leave to someone other than natural heirs at law, that's not going to happen unless you actually have some sort of plan in place. So what are we looking at here when you're trying to accomplish with an estate plan? An estate plan, by the way, when I mention estate planning, I'm mentioning all sorts of documents. I'm only mentioning trusts, I'm mentioning wills, I'm mentioning I mean durable powers of attorney, healthcare proxies, and so forth, which would go into. So the basics of it is that you put this in place so that the right people get your assets, right? Another thing, key crucial point that a lot of people tend to miss out as well with planning objectives is they're thinking about death. And of course, that's what a will is for, right? A will is only valid after you die and after it's been probated. We'll get more into that in a minute, but they're only thinking naturally about what happens after I die. But you shouldn't only be thinking about what happens when you die. You should also be thinking about what happens if you become incapacitated, right? Because if you just create a will, a will only takes effect after you die. So what happens if, for instance, you're in a car accident, you have an illness, you're incapacitated, you're in a hospital bed? Who's going to make financial decisions on your behalf, right, while you're incapacitated? It doesn't have to be a terminal illness. It could be at any point you can recover from it. But in the meantime, if you can't make those decisions, who is going to make those for you, right? Either be it financial decisions or healthcare decisions, right? So that's something that we always put together, obviously, with an estate plan package. One is the durable power of attorney. Durable power of attorney is basically putting a document in place, power of attorney, appointing who would be your attorney. In fact, that's to make financial decisions in the event you become incapacitated. That is why we call it durable. Durable means it still has effect after you become incapacitated, right? Typically, we see this most commonly, with spouses. Each spouse appoints the other one as their attorney, in fact. And then complementing that would be what we call a healthcare proxy. Healthcare proxy, essentially, who do you want to make medical decisions when you can't make them, right? And again, usually it's spouses, but it might not always be the case, right? You might want to have someone different doing that. If you don't have these documents in place, then what happens? Well, it depends on a lot of factors, but generally speaking, you're going to have to go through, whoever is going to try to take care of things would have to go through what we call guardianship proceeding in the surrogate's court. And that's something that these documents avoid. If you don't have these documents, then typically you have to have a guardianship proceeding. Someone has to go to court. A judge has to make the decision on who would be appointed as the guardian. You'd have to file accountings with the court. It's public. For the most part, it's time consuming and it's expensive, right? So these documents avoid that step, right? Because you're already making it clear who you already want during your lifetime. And in that sense, it provides more continuity, more comfort, especially if you have a spouse or kids or so forth. If you have real estate, for instance, that you have to deal with, you don't want to be stuck in a guardianship proceeding. And lastly, a guardianship proceeding, the judge ultimately determines who is going to be appointed the guardian. They're going to ultimately determine what's in what they think is in your best interest, right? And it might not necessarily be the person that you want taking care of your financial assets, for instance, or of your healthcare decision making. You might want a specific person. The judge decides otherwise, right? And so these two documents, while being relatively straightforward, are really key in order to make sure that the right person is making the calls honestly in your most vulnerable moment, right? It's the most vulnerable time of your life if you can't make those decisions on your own, right? So I got some basic terms and definitions here. I throw these in. I'm not going to go through them one by one, but some of them are important. They're mainly confined to New York State. I'm also licensed in Florida. And in Florida, the terms are slightly different, but we've got executor, we got testator, intestate, intestate rules, administrator. I just throw these in there because throughout my practice, I hear a lot of misconceptions. Sometimes people call it testate and executor, or trustee, or they call a trustee an executor or administrator and so forth. So this just kind of spells out what is what and when you use those specific terms. So let's say, for instance, let's begin with a will. What is a will? Everyone knows what a will is. I don't have to go into detail with that. You draft a document, you sign it here in New York State, as in most states, you sign it before two witnesses. And then afterwards, after you sign it, and there's also called a self-proving affidavit and so forth, that will then determine if only in the event that if you die, who gets to be in charge of your estate and who gets the benefits of your estate, right? So so when you pass away, first very important thing is you're going to nominate what's called an executor in your will, right? The executor is who you nominate to be and that could be a beneficiary as well. And the executor is going to be the one that has the responsibility to what we call offer the will into probate, right? Probate is just a term from Old England, a long time ago, but that's basically, they would go to surrogate's court if you live here in New York State. in your local county surrogates court, and they'll offer it. They'll go up to the court and say, here's the original will, and I'm the named executor, and I want to offer it for probate. That basically means going through a court proceeding where the will is validated, and then you are the executor is appointed as the official representative of the estate. So there are generally, I just put a few basics here with the process, right? But basically it's oh, I'm going too fast here. But basically what happens during a probate proceeding? A probate proceeding can be, it all depends on the facts and circumstances of death. It can be very straightforward. It can be very complicated, even when you don't necessarily think that it's going to be complicated. And I'll give you some examples. When you hear, at least in New York, if you need to start a probate proceeding, it depends on who your heirs at law are. Even if you have no heirs of law actually listed in your last will and testament, they still have to be given notification. So let me just give you a very quick example here. I'm currently dealing with an estate proceeding where we are putting together a probate petition. Now, the probate petition is based on a last will and testament of the deceased. I am the attorney for the executor of the estate who was nominated in the will. So far, we initially began this process of putting the petition to offer to the court in August. So it's been about 6 months. And I'm sure when the person, the deceased, when he created the will, I didn't create the will, by the way, was putting it together, didn't think it was going to be as complicated as it is, but it is. And why is that the case? Now, this is a little bit of an extreme example, but not terribly uncommon. The reason being why it's taking so long is the deceased passed away without a surviving spouse, without any children. His parents had already predeceased him, or his siblings had predeceased him, right? So what happens? I mean, none of them were even listed in his last will and testament. But what happens is now is New York law requires that those who would take if the will was considered to be invalid, they have to be given notification of the proceedings, of the probate proceedings. So what happens in this case? Now we have to look at the intestacy rules of the state of New York. Who would take if this will was considered invalid? And we have to give them an opportunity to try to contest it. Well, it turns out we thought that he only had 3 cousins, living cousins, and an aunt. It turns out he had 12. We actually had to go on to we had to get a genealogist involved. We had to go and look up all the records. We have to track down all these cousins, and we have to put a family tree together. Someone has to put an affidavit, and it has to be a non-interested party that confirms who all the living relatives are. And then we have to send them notice, and we have to ask their permission. Please, can you sign this waiver so that we can probate the last will and testament? And then if they don't sign it, then we have to go through a crazy process called citation, where you essentially, cite them with process, and they have the opportunity to come to court, and it takes a very, very long time. The bottom line is that even when you think that your last will and testament, you might go, oh no, it's very straightforward. I'll just do a will. And it's going to be very easy to probate. Well, not necessarily the case, especially here in New York. There can be a lot of curveballs, and the court is not going to accept that petition until we have all our ducks in a row, right? Luckily, in this situation, by the way, we were reaching out, we got everyone to sign and so forth. We've got a genealogist that's signing off affidavits, but it was a hell of a lot of work, and it was a lot more work than the executor thought it was going to be, right? And why am I mentioning this? Because we're going to get into trusts and how trust can potentially avoid this.
Chris, we have a question from Susan.
Yeah.
I guess qualities of looking for an executor or power of attorney. I guess somebody who is, reliable, who's, available, who's, and anything else specifically when that's a big decision, right? When you're working on these, when you're working on these tools, it's sometimes I think that's the impediment to finalizing these documents, right? You don't want to offend your in-laws, right? You don't want to offend your brother or your sister. So Any, I guess, practical ideas for making these decisions?
Yeah, it's a great question. And it's an important question as well, because ultimately the executor is going to have the responsibility of filing the petition, right? It's going to be the named executor. And they also are going to be the fiduciary of the estate. They're going to have the responsibility to, pay claims, to marshal the assets, what we call it, liquidate the assets, potentially, depending on the assets, potentially reinvest them, deal with the beneficiaries, ultimately make distributions. And that is an important role. That's a really important role. And some people don't want to do it as well. You got to remember, an executor is a fiduciary and has a fiduciary obligation to the estate and ultimately to the beneficiaries. So if they screw up, they could actually be held personally liable. If, for instance, they make distributions within a certain period of time before creditors have had the opportunity to make a claim, they could be personally liable for that. So some people are very uncomfortable with being appointed executor. Having said that, it's not like you have to reach out and ask. You can always, we put in the wills, like, there's a certain person. If not that person, then, second person back up, third person back up. And for instance, we always encourage to have backups, just in case that other one person, because otherwise it gets a little more complicated. If no one listed in the will wants to act, not uncommon. We've dealt with it before, and there's ways of dealing with it. So, but yeah, that's a really good question. But the qualities that you want to see, just to answer your question a little more specifically, is someone that that can stay on top of things, that is reasonably organized, that is actually going to take it seriously, that is, you don't have to be some money manager or anything like that, but someone that can be fiscally prudent, that understands that doesn't file their tax returns late every year, owes the government serious amounts of money. You want to make sure that they don't bring those type of those negative qualities to your estate proceeding.
Just so you understand, with when you have a will and you name an executor, under the real estate umbrella, technically for all the real estate brokers and buyers and sellers, you can't, until that will is probated, or if you pass away without a will and there's administration proceeding, you can't sell your apartment, you can't get rid of assets. Just because you have a will, say for the classic example, both parents have passed away and there's one child. Simply because there's one child, that child does not, let's call it an adult child, have the ability just to sell an apartment or take money from a bank account until the the surrogate's court recognizes that person as the executor or the administrator if there isn't a will. So there's a proceeding. A will doesn't negate the need to go to surrogate's court.
Yeah, and just that's a great point as well, because we've also had clients approach us, say, oh, well, I have a copy of the will. It's like, where's the original? Well, I don't know. We made this will 10, 20 years ago. I don't know where the original is, but the copy should be sufficient. And I tell them, I have to break the news to them. Well, one, if you don't have the original, then the law here in New York presumes that the person that made it destroyed it. And so you can't probate a copy typically. There are some very limited circumstances, but it's very difficult. And two, you have to actually go through the probate proceeding. And someone just asked a question here, which is actually, how long does that typically take? And the question is, it depends. It's like, let's say, for instance, in the circumstance, now if you have a surviving spouse and kids and everyone's just in agreement, it depends on the county as well. Kings and queens are notoriously slow. New York County isn't as bad, but they can be a little bit picky. Another thing as well is in New York State, for instance, everything is very front loaded. They will not issue those letters until they're entirely comfortable with issuing them. There's a lot of more documentation than, for instance, compared to Florida. Florida is much faster. I can get letters in a week in Florida, but then the court likes to be very involved in the entire process. Here in New York, the court is very involved right at the beginning, and then once letters are issued, they're sort of like, no, we don't want to hear about it unless you have an issue, right? So, beneficiary complains about something, creditor issues or something along those lines. The court just can't be bothered. But the problem with that here in New York, I would say, you should give, if it's uncontested, non-controversial, you have everything in place, maybe 2 to 3 months, maybe. But in Kings County, I did one last year. Kings County became a bit of a basket case because one of the judges got removed and another of the surrogate judges resigned. There's only 2 judges there. So at the end, that was at the end of 2021. And I was probating a will right during that process of time. And that took us 7 months to probate. In the meantime, there was a house, there was a mortgage, couldn't do anything about it. It was empty. We couldn't sell it, we couldn't rent it, couldn't do anything. It just sat there vacant and empty in Brooklyn. So that's another drawback here of just trying to leave everything to probate. And there's the general idea. So it could take, honestly, and like it can take substantial time just to put the petition together. Like that example I've just given, we're 6 months into it. And we're only just getting the last piece of the puzzle before we can present it to the court. So we've been dealing with for 6 months, putting the petition. I'm going to submit it to the court, and I can guarantee you they're going to come back with me wanting X, Y, and Z in addition, right? They always do that. So I've been speaking right now for 10 minutes. I don't, now I actually do want to get into the whole, I just want to make I just want to go very briefly into what's called probate, non-probate assets. You could take a look at it in more detail here. So what's considered a probate asset, right? Probate asset, by the way, is just something that needs probate in order to be transferred. Like a will needs to be probated, or administration proceeding if there's no will to transfer to beneficiaries or as at law. So typical probate assets you see is like, property in a single name. If it's what we call tenants in common, there's joint owners of property, but there's no right of survivorship. And also potentially what we call community property. Not getting into that. Community property doesn't exist in New York, exists in California, Texas, and so forth. It could be relevant here if you had previously lived in one of those states. But that's beyond the scope of this presentation. Non-probate assets, by the way, a trust, I'm going to get into that. A trust is considered a non-probate asset that does not require probate. It does not require probate or administration proceeding. And some of the typical type of instruments you see is, lifetime transfers to revocable, irrevocable trusts, jointly held bank accounts, with typically those have rights of survivorship. Beneficiary designations on life insurance, IRAs, 401ks, totem bank accounts, for instance, joint tenancy with rights of survivorship in real estate, including what we call tenancy by the entirety between couples, right? Those do not require a probate proceeding, right? That is automatically inherited by operation of law. So, if you and your spouse are tenants by the entirety on real estate, you pass away, one spouse passes away, the other spouse doesn't need to go to probate because it's already operational. You just have to prove the other spouse died and that they're the owners 100%. However, by the way, a lot of people that are out there that say, hey, we already have everything. I'm married and that's how we want it. When if I die, my spouse gets everything. But just consider this. What happens if both of you pass away at the same time? Car crash, accident, or the last survivor of you passes away, right? Then you will need probate. So you always need to think ahead of stay ahead of the curve here. And that's, by the way, a benefit of trust. So I went into some little, real estate here. I'm not going to go into that. We'll send this out. So, I'm going to go in right now into trust. So what is a trust? Some of you might be a little more
familiar.
Sorry.
From just a quick note, and you touched on it quickly, but just as an attorney, but obviously not a state of planning attorney, if you get nothing, then this out of the trust portion, and Chris just mentioned it very quickly, but he'll stress it more now. The beauty of a trust is that it avoids probate, right? Avoids going to court, which is why it's such a powerful tool. And, having Chris at the firm and not really knowing as much about estate planning before he was here, I mean, it's incredible how many clients and even estate planning attorneys don't use this to their advantage, right? Think about months and months and of court going to, trying to find family members that you haven't spoken to, or the decedent hadn't spoken to, or somebody comes, from left field, from, Kalamazoo, and claims ownership or claims an interest in, a bank account. So it's such a powerful tool there. We'll talk about the different types of trust, but the basic concept is that it avoids probate. And Chris will talk about, how it's more of a living will, and I love how you kind of phrase that, but I'll leave it to you.
Sure. Yeah. So that's exactly correct. It avoids probably the biggest opportunity to using a trust. It avoids probate. And why is that? Because trust, and typically when I create, it's what we call the most common one is what we call a revocable trust. This irrevocable trust, which the person that creates it can't change it. I'm not going to go into that. That's very technical. That's usually used for tax planning, for asset protection, and so forth. That's a little bit beyond the scope. I will make some comments about that. But the most common instrument that we tend to see is for what we call succession planning purposes, which is the revocable living trust, right? The revocable living trust, what is it? So the trust is basically a trustee. And the most common type, I'll just give an example with spouses, right? Spouses, spouse one and spouse two. So spouse one, typically there's three parties involved in the trust, right? Legally, this is settler or grantor, but that's usually, it's the creator of the trust. The person actually creates it and funds it. Then you have the trustee who holds legal title of the trust, right? They're not necessarily, it can be a beneficiary, doesn't necessarily have to be a beneficiary. And then lastly, you have the beneficiaries who essentially own the rights, the economic rights to the trust property. Right. And this is, by the way, a private document. It's not like you can, this is sort of analogous to the trustee as the director of a company and the beneficiaries as the shareholders of the company. It could be, you can use that analogy, but it's not an entity, separate entity where you have to register the trust. The trust is a private document, right? It's like it's another advantage of the trust, right? It's not registered anywhere. It's just essentially like a contract, and it's typically how we create these is that the client that comes to us, they are usually the initial settler, the creator, they initially the trustee, and the beneficiary during their lifetime, right? So they are one and the same person, and then in the trustee, so they have full control of it over their lifetime. They can revoke it, they can amend it, they're the beneficiary, they can, so for all practical purposes, it's as if they still own it outright, right? Any property that's transferred to the trust. But the key fact here is, and also to avoid the doctrine, what we call merger, is that the trust needs to have certain, and it does have certain terms in it that dictate who becomes the successor trustee, right? Either in the event of for initial trustees incapacity or death, and who are the beneficiaries in the event of the client's incapacity or death, right? And typically with spouses, we see one spouse dies, the surviving spouse becomes the trustee and the beneficiary. They can do what they want with it, but then we also put terms in it. Well, what happens if the spouse predeceased them or dies at the same time? And for instance, they have children, right? Minor children, that's very common as well. Then we put provisions in there that say, okay, like the kids, it's split up equally into sub-trusts. And you can put all sorts of terms. The trust is very flexible, and you can say, well, the kids can inherit age 30 or after graduating from college or something like that. They can't take it outright until that whatever they specify happens. So what happens here in this situation is, and then you appoint a successor trustee, someone that's a trusted party to make necessary distributions, what we call discretionary distributions during that time to the children if necessary for health, education, maintenance, support, what have you not. The key here is another thing as well is it protects against those potential children's creditors, or it protects them against if they have substance abuse issues, for instance, right? And it's not just children, it can be other types of beneficiaries as well. The key is a flexible document here, but ultimately it avoids probate. You create that trust deed, and then you title assets to the trust. Now, how do you title the assets? Some can be easier than others. Rolex watches, personal property, for instance, things, whatever you have around your house that doesn't have a deed or anything to it, you could just do a declaration. I actually do that with my trust. Do a declaration. I hereby everything that personal property that I own is transferred to the trust. That's enough under New York law. If you have real estate, you can transfer real estate. You will need to create a deed. Essentially, if you have real estate in your own name, you would then transfer it to you as the trustee of your trust, and then record it, and then it becomes valid. And that's a relatively straightforward process, right? And once the property is formally transferred to the trust, and then it's owned by the trust. So if something happens to you and you pass away, it's essentially turned into a non-probate asset, right? It means that you don't have to go to probate, especially real estate. The real estate is owned by the trust, and you pass away, the successor trustee can step into, that's nominating the trustee, can then step in the very next day, and then sell the property if they want. You don't have to go to probate court, completely avoids it. You don't have to follow that trust deed. Remember, a last will and testament, that's public information, right? Everyone's going to be able to see that if they wanted to. They're going to be able to see the inventory of all the assets in your estate, but this completely avoids it, especially if you're able to title everything. Now, together with a trust, by the way, I always say, look, you can't just have a trust in itself. You always have to have a last will and testament. Typically with revocable living trusts, I create what's called a pour over will. It's a sort of a fail-safe. Basically, if property was not properly transferred, or you bought and sold and things were still in your own name, you forget something, then it says, oh, anything in my own individual name at death that belongs to my estate will then be poured over into the trust, right? So that will would have to be probated, but it would only apply to any property that wasn't validly transferred to the trust during lifetime, right? And it makes things a lot more straightforward. So, and especially here in New York City, and how Andrew mentioned is, we do have a lot of estate sales as well. And those can just be a pain because estate sales take so long. You have to get the courts involved. You have to get letters issued. And it's not unusual to see property just standing still for up to a period of 1 year, maybe even.
Yeah, I see Michael Milani about co-op ownership. Co-op ownership in the name of a trust. We actually, Chris and I met with a top real estate team, and his board, or the lead of the team and his board, along with the managing agent, trying to explain to them why trust ownership for co-ops is not risky as long as there's obviously the correct safety measures in place. A lot of it is just fear of the unknown, and I hate to say lack of sophistication. I would say about 50% of co-ops do allow trusts. A co-op, needs to feel comfortable that they're going to, get paid maintenance, right? And there's somebody on the hook for liability. By putting a few safety measures in place, we can accomplish those goals, such as a guarantor, such as an occupancy agreement, who's living in the property, money in escrow to cover maintenance in case there's a default. So we find, and it's interesting, I can say this as a real estate attorney, most of the attorneys that represent the buildings obviously concentrate in real estate, not estate planning. So when they see a trust, they're not used to reviewing these agreements, and they kind of push it off, not all of them, but they don't want to deal with it. So, and the buildings don't want to deal with it. But the point that the broker was met with was trying to make to his board was, it makes the building more attractive, right? You give the buyers more options, and a lot of people of means, families, investors, they want to buy in trust. So we all know our city, when it comes to co-ops, is pretty antiquated. So this is one tool that can make co-ops more attractive to the consumer. Yep. Chris, there are a few more
just a few more points, and then I guess I'll answer some questions. Just a few quick points, because I do get these questions all the time. You have revocable trusts, irrevocable trusts. What's the difference? Irrevocable trusts mean that The person that creates it can't revoke it, can't amend it, and so people ask, well, why would someone do that if they can just do a revocable trust? There are very specific questions. It's the specific circumstances for that. Typically it's more for complex gift and estate planning to take things outside of their estate if they were to pass away. U.S. estate taxes go up to 40% of fair market value, so that could be an issue for some high net worth individuals. Having said that, U.S. estate and New York State estate taxes don't apply to 99% of the population. There's currently a $13 million exemption per person. So if you die with assets for up to 13 million, you pay no U.S. estate taxes on the federal level. New York State slightly lower, it's $6 million, but more limited assets. And by the way, if you're U.S. citizens and your spouse transfers to spouse has an unlimited exemption. You can transfer $1 billion to your spouse and at death or during lifetime, and there's not going to be any U.S. estate or gift tax, right? Another area is for asset protection, irrevocable trusts, because then you essentially don't own it; the trust owns it. A revocable trust, you're considered for creditor protection laws, you're considered zoning it, so it can always be taken by creditors. Having said that, irrevocable trust asset protection, you cannot be the beneficiary. Typically, it's what we call a self-settled trust. Otherwise, that is invalid in New York and vast majority. You'd have to go to a state like Nevada, Wyoming, Alaska, so forth, and the costs are expensive. You usually have to, have liquid assets there in that state. And honestly, in my personal opinion, this differs between practitioners. The law is very unsettled, whether that even works because of full faith and credit of judgments between states. So that's basically what. And then irrevocable trust. Lastly, you've got Medicaid asset protection trust, right, which is a little beyond the scope. It helps avoid potential Medicaid claims if you have to go to nursing homes, for instance, end of life. That's otherwise this. Otherwise, we just use a revocable living trust. So I know we're limited on time, so I'm just gonna look through some of these questions because they've been building up here. So one is from Hal. What is the authority and responsibility to others in the will? Are they final say on all matters? Hal, so an executor is has to follow the terms of the last will and testament, right? They can't just do what they want to do. Now, having said that, they might not be able to follow all the directions because perhaps the estate is insolvent, or perhaps there's not enough assets in the estate to make a distribution, and so they have to pay off creditors, right? Any necessary creditors to the estate. And by the way, on that point, a trust is also a valuable tool because creditors typically only get, they only go after, it's not impossible for them to go after non-probate assets like those transferred to trust, but a lot more difficult because probate, creditors can then make claims on it, but non-probate assets, could a creditor still go after it? Yes. It doesn't make it after death. I'm talking about, by the way, after the person's died. Could they go after it? Yes, but it's more difficult because there's no probate proceeding, right? So there isn't that opportunity for them to actually make a claim. So that's another point as well. But yeah, an executor has to follow the terms of the will, right? The terms of the will say such and such, then they have to abide by them. They can't make it up as they go along. They can't decide what they think is fair. Sometimes they have to deal with some curveballs as well. If there is a valid dispute between beneficiaries or creditors and the executor, it is typically taken to the judge, right? Usually that's through a judicial accounting proceeding or so forth. And that's when things start getting a little bit crazy with litigation. So second question is Melissa. I have a living trust here in Europe. I'm planning to purchase a condo in Florida with another person with the right of survivorship. Should my interest be put into my trust? So just to break down a few things here. So if you're purchasing with another person with right of survivorship, right, then what's going to end up happening is when you die, the terms of the deed, the right of survivorship in the deed is going to control, right? So If you, for instance, Melissa, buy with, with John Doe, and then you die, then right of sight of John Doe is going to automatically inherit 100% of the property, regardless of whatever you have in a will or a trust, right? So now, if you don't want that to happen, then you don't want a right of survivorship in the deed itself. What you want to do is you want to, if you want it like essentially like a 50-50 split, you want that to be treated as what we call tenants in common, so that if you pass away, and then what you can do is you can have, for instance, John Doe as a tenant in common, and then you as the trustee of your revocable living trust as the owner of the other half of the property. That way, if you pass away, then the ownership would be, John Doe with 50% and you with your living trust with the other 50%. By the way, living trusts are generally, that are created in New York are generally valid in Florida. There's really no issue to it. Florida does have some rules that are a little bit different. They usually more apply to homestead, Florida homestead. There's actually a lot of people know Florida homestead about creditor protections. What they don't realize is there's some forced heirship rules there specific to spouses. So that's something you should keep in mind. But if it's not going to be homestead, it's going to be a rental property should be an issue. Gene, what are the tax consequences of putting a property in a trust, benefit of a trust over an LLC? Oh, great question, actually. Revocable living trusts, I say, are tax neutral, both for income tax purposes and for estate taxes and gift tax purposes. They neither increase nor diminish taxes, right? The reason being is because a revocable living trust is considered transparent for tax purposes. The IRS doesn't see it, they only see the settlers, right? And so any income that's being received by the trust is reported by the settler on their individual tax returns, for instance. Now, a benefit of a trust over an LLC, they're two very different vehicles. A trust is a little more straightforward. LLC, you have to actually register with the state. And having said that, an LLC does provide privacy, for instance. We see a lot of clients do both trusts and an LLC. They usually buy property in the name of an LLC, so you use the name of the LLC on the deed, and then the membership interest is owned by a trust, right? So if they pass away, then the membership interest is already taken care of. But from a tax perspective for an LLC, it really depends. The default rule is that LLCs are transparent. It's taxed either as a partnership or disregarded entity, so to the individual members. You can do S Corp elections, things like that. That's beyond the scope. I can't get into that. The one downside of LLCs, by the way, is that you don't qualify for a star exemption. So if it's your primary residence here in New York State, you can't do the star exemption, which is the discount in school property taxes. That's one. Two, if you have more than one member of the LLC and it's your primary residence, and then you sell it, you do not qualify for the primary residence tax exemption, capital gains exemption of up to $500,000 for spouses filing jointly. So that's another thing to keep into consideration when you're thinking of an LLC. But otherwise, it's very common for an LLC to be used for rental property to second home, for instance, and then a trust to actually own the membership interest. And next one, Megan, the house we own in Connecticut is only in my spouse's name, both the mortgage and title, since he bought the home prior to us getting married. If you were to pass away, would the home have to go through probate? Good question. Yes, it would. It would have to go to probate because it's only in his name, even though you're actually both married. It would have to go through probate, and depending where you live, if you actually, if you live in Connecticut, it would, what we call original probate would be in Connecticut. For instance, it's a second home, you live in New York, then you'd have to do original probate in New York, then what we call ancillary in Connecticut. Connecticut has very similar rules, intestacy rules to New York. I don't want to say them off the top of my head because I'm not licensed in Connecticut, but spouses do have a certain right to the property, but typically it's a spouse. But here's the issue: if, for instance, you as the spouse, typically the rules are if your spouse was to pass away, survived by a surviving spouse and children, then intestacy rules typically dictate that the spouse usually gets like, the surviving spouse gets like a half, and then the surviving children get the other half. And that can cause a real issue, especially if it's a primary residence, because now you essentially own a property together with your children, right? And what issues can that cause? Well, you know, if you're estranged from your children, if they turn 18 and they decide that, you know, if you want to sell it, refinance it, whatever, well, now you've got this issue because the children are legally have a right to the property. So it's always good to have some sort of planning, like a last will and testament in those kind of circumstances. And ideally, perhaps even a trust, just to completely avoid probate. It also avoids probate in Connecticut. Michael, I think we answered this. How about co-op ownership? Andrew answered that. Co-ops are starting to warm up, but you know, about half of them to this day. We're working on it. We're working on it. We're hoping you can.
But yeah, if you do a lot of work in a building as a broker, or you live in a building, it's just a matter of, you know, having, you know, some sort of presentation for the board and the managing agent. Not to say that it's easily accomplished, but we've definitely had success. So it brings value to the building for sure.
Yeah. Let me just.
We have 1 or 2 more minutes, Chris.
Yeah. So Wendy, in Megan's scenario, would the property go to the surviving spouse, or could be named to any living child as the beneficiary? If it depends, if the husband dies without a will, it goes by intestacy rules, which is like I mentioned, typically split up between surviving spouse and any surviving children. Surviving spouse, there's no surviving children, then usually it just goes to the spouse. The husband can, in that situation, for instance, the spouse can potentially leave it to children and not the spouse, but every state has some form of what we call spousal right of election. You can't completely disinherit a spouse. It varies between states. Here in New York, the spouse at least entitled to a third of the deceased spouse's estate, and that's an affirmative election they would have to make. So if a spouse decides to leave nothing, then the surviving spouse can go and say, hey, I want to elect my right to a third of the estate. So it really depends. Connecticut has some weird rules, by the way. Connecticut, I won't go into it because I got to answer these questions. Message from Hal: what are the financial aspects, trusts, taxes? It's neutral. It's as if like I mentioned before, it's as if the settler is doing it themselves. But if the settler dies, by the way, then the trust becomes irrevocable, and then the trust is essentially, there's 2 options. It can either be taxed in the name of the trust, or it can be taxed on a distribution to the beneficiary. That ultimately depends on the assets within the trust, and so forth. Plan on dying. I plan on his dying first. All right. Let's I'm not going to say let's hope. But can you create a trust for a client who lives in New Jersey? Yes, I can. I'm licensed in New Jersey as well. Same rules. To be honest, my experience with probate proceedings, by the way, is really in New York. I have very limited experience with probate proceedings in New Jersey. I do trusts for New Jersey, wills in New Jersey, and so forth. But I can't give an analysis of how much you would be avoiding in New Jersey, but I can certainly do them in New Jersey. What about property that is in another country? Are there any specific complications? Excellent question. It's, I think, a good one to leave off on. Property in another country, we deal with this all the time. I deal with a lot of cross-border matters. I have a specialty with international clients, actually, and planning for international clients looking to purchase U.S. real estate and other assets. I structure that in a way. International clients have some different rules to them. But let's say, for instance, you're a U.S. person with property abroad. What I typically, it depends on the property, depends on the country, it depends on the jurisdiction. But ultimately, with a trust, most countries don't recognize trusts. They operate in what we call the civil law jurisdictions, right? Trusts are a creature of what we call common law, English common law. And so only common law countries tend to recognize trusts. So let's say, for instance, you have a house in France and you die and you say everything goes to my trust. Well, that's going to be an issue in France because the whoever does the deed transfer is going to say, well, we don't know what a trust is, so that can't be the owner. And then you have an issue. So what we always say is, if you have property in specific countries, you need to speak with a estate planning attorney in those countries and make a specific plan for those countries, including a local last will and testament. And obviously you always have a last will and testament and trust and what have you, not for your US side assets, but assets within the United States, because the different jurisdictions have different rules, especially when it comes to real estate. And so you don't want to ultimately just assume that the US plan is going to work out, because it might not, and it probably won't.
I know some people are logging off. I want to be respectful of everybody's time. We will send you a copy of this written presentation. Also, just as a quick note, if you or your obviously clients or friends, family members have questions, we initially do a consultation, free consultation, and then figure out the best course of action. You'll have my information and, more importantly, Chris's information. But thank you so much for joining.
Thank you.
And if you have specific questions, such as Medicaid trust, anything of that nature, just shoot us an email. We'll get back to you as quickly as we can. All kidding aside, estate planning attorneys aren't like real estate attorneys. We don't. Sometimes it takes a little bit more time to respond because their work is a little different. But Chris is very responsive. Real estate attorneys were obsessive with returning phone calls and emails in minutes. Estate planning attorneys, spend more time drafting and in court. So we'll definitely get back to you, but it's not immediate all the time.
All right. Thank you, everyone, and take care. Have a good day. And yeah, we will be sending out, I think Andrew mentioned, a copy of the presentation together with a video link as soon as we can. All right. Thank you, everyone. Have a good day.
Thank you.